Our final speakers of the day are attorneys from Pitney. We've got Dowd and Lindsey Viscomi. They're going to go through two of the most important HR transactions that you'll face. Okay, we're going to do terminations and investigations of harassment and discrimination. These are probably the two issues that are most likely to land you in court if done improperly. So these are really important. Join me in welcoming Glenn and Lindsey.
Thanks, Diane. Thanks, Diane. Can everyone hear me okay? How terrific is it to be here together in a room without masks, without feeling like we're presenting a danger to everyone else? Is this terrific? I got to tell you, after this long pandemic, it's just very heartening to be up here and to do this, and Lindsey and I are thrilled to be here. I'm with Pitney. I'm an employment lawyer, and I have been for 33 years, advising employers on all aspects of employment law, including the topics we're talking about today. Lindsey does the same thing for a slightly shorter period of time than 33 years, believe it or not. But we hope to walk you through some of these critical employment-related concepts. And as Diane said, the ones that are most likely to lead you into court. I am an active trial lawyer. I've tried 15 cases to verdict in state and federal courts around the country and had literally dozens of other public hearings and other bench trials and things. So these concepts are not foreign to us. And I'm always delighted to answer questions, as is Lindsey, whenever they come up. So if they come to mind, please feel free to fire away. So I want to talk first about some baseline principles that are important to understand as we get into this issue of terminating employment, whether we can terminate employment. And I think the first place to start is at first principles. The first principles is, what are the basic rules of the road that we should be thinking about as HR professionals in terms of dealing with employees, disciplinary issues, terminations, and the like? And of course, employment at will comes up. And what is employment at will? What does it really mean? And the answer for employment at will is a really nifty concept if you're an employer. It means that you can hire, fire, terminate, promote, demote, transfer, increase pay, decrease pay, whatever we like to do for any reason or no reason at all. So under strict employment at will, if I want to say, it's a Thursday, I actually enjoy demoting people on Thursdays, I think I'm going to go pop off a few, right? That is an absolutely, under strict employment at will, an absolutely acceptable kind of rationale. But what we also know as folks who deal regularly with this subject is that employment at will is largely a fantasy in 2022, right? That we have one of those uniquely legal creations, a rule that is really defined by its exceptions. And it's the exceptions that the people in this room know about and regularly counsel with their business partners to communicate and make sure we stay on the right side of these issues. And chief among those exceptions is the idea of contracts. So if we talk about express employment contracts, there are a select group of people, high-level people, C-suite, mahogany office types, who themselves have the leverage in a negotiation to be able to say, I don't accept employment at will. I want to know what my pay is going to be and what's going to happen if it's diminished. I want to know what happens if you terminate my employment without cause, and perhaps even a good reason kind of concept. If you demote my pay, if you move me to another place, if you diminish my responsibilities, I have the right to pull the plug on this arrangement, and there'll be some kind of severance obligation that you, the employer, will have as a result of me voluntarily terminating my employment. That's a very small piece of the population who enjoys that kind of leverage to be able to bring about that kind of a contract, right? We also have this concept of oral contracts. So when most of us think of a contract, we think of something that's in writing, that a pointy-headed lawyer like me helps you draft, right, so that it's memorialized. But there's really, in most cases, nothing that requires a contract to be in writing for it to be enforceable. So if I were to say to Diane, I'll agree to sell you my car for $15,000, she says, I accept. There might be issues of proof. We might haggle over who said what at some point. But by and large, a contract's equally enforceable, except for some notable exceptions. But Equally enforceable if it's oral as opposed to if it is in writing. And as we've seen over the years, and I'm sure you've had in some of your situations, supervisors can get themselves into some real sticky situations by using unhelpful language and words like will and shall and always and never, kind of the absolutes, instead of the favored lawyer weasel words, maybe, we'll see, as things pan out, right? So again, oral contracts are kind of another way that employment at will can be eroded, sometimes unconsciously by supervisors who do it in a well-meaning kind of way. Collective bargaining agreements, what is that? That is when a group of people under protection of federal law decide to get together and appoint an agent being someone who's able to negotiate the legal rights and responsibilities of another person, to represent a group of people. And under this protection of federal and state law, you have this group of people who are able to combine and create leverage that maybe somebody with a much higher position has, but collectively they have, to say, no, employer, we're going to negotiate with you about various aspects of employment at will we don't like. When can you terminate me? When will I be promoted? What will my pay be? Under what circumstances will my pay increase? And all of those things are, again, a collective effort to erode this principle and to create exceptions to this very broad concept of employment at will. And the final category of contracts we have are what are called implied contracts. So if I was working with Diane, I said to Diane, I need you to do a special project for me. It's going to require a lot of work, a lot of weekends. I want you to go hard. If you get this project done by November 30th, I will give you a bonus equal to 10% of your compensation for the entire year. And Diane works her brains out, very hard at work, and on November 29th, just as she's about to get this over the finish line, I say, sorry, Diane, you're terminated. Didn't quite make it to the finish line. Now, did I have an express agreement in that concept with Diane that I would not terminate her unreasonably just short of the finish line where she earned this benefit? No, but in many cases, the law will imply that a term of that sort is in place, a kind of a concept of good faith and fair dealing, not an inappropriate means of keeping someone from earning the benefits of a contract, will be applied in that circumstance to limit the employer's abilities, often under employment at will. So this is kind of a first big group of exceptions to employment at will. And the next big group of exceptions, of course, we know, is that this any reason, no reason at all has all of the exceptions that we heard from Tiffany just a moment ago: race, gender, disability, prior complaints, taking leaves, exercising rights under workers' compensation statutes. And we have this whole plethora of claims that come up out of those statutes when we get into a termination situation. And I can tell you, having done this for 30 years, one of the most common things I hear from my clients when I first come in is, this is going to be a piece of cake. You can look through this file all you want. You can talk to other people. I never once mentioned this person's ethnicity. I never once said anything about this person being pregnant. This should be a walk in the park for you. And of course, those of us who practice in this area know that that, again, is a highly simplistic and not very realistic view of this, because of the way litigation claims, discrimination and retaliation claims are litigated. And I'll try not to be super lawyerly and wonky on you, but it's helpful to understand this. And I think helpful for you to understand the very critical role you play within your organizations in keeping these claims from getting traction. So if I pull out of here, I have a car accident. Somebody just whacks me when I pull out of the driveway of the Trumbull Marriott here. I want to bring a lawsuit. I'm a plaintiff. I have a lot of burdens. I have a burden to prove that the person who hit me had a duty to operate their vehicle with reasonable care. I have a duty to prove, me, the plaintiff, that that person failed to operate that vehicle with reasonable care. I have a duty to prove that my injuries proximately flowed from the breach of the duty to act with reasonable care. and I have a duty to show that I was damaged as a result of that. If I don't show any one of those elements, my case goes out. I am done. I lose as a plaintiff. And when the civil rights statutes were first implemented in the 60s, that traditional kind of English system of how claims are proven was imported into the discrimination and retaliation claim context. And nobody was winning the cases. Employers figured out very quickly that if they scoured their records, they took out incriminating kinds of statements or just stopped making them, that it was very, very hard for a claimant in those circumstances to be able to prove a claim. So what the Supreme Court did in the early 70s, as Tiffany and I know on a regular basis, is they came up with a burden-shifting test, really unknown to the law beforehand. And let me give you an example of how that works. Let's say I get terminated. I'm an employee at Dade Pitney, and I get terminated. I have to show some very minor things. I am a member of a protected group. So I would say I was born on June 15th, 1961. I am 60 years old, or 61 years old, God help me. So I am now in a protected group under federal age discrimination law. Something bad happened. I was terminated. Number 2, satisfied. And just a general statement, not a very high bar, a general statement that there were circumstances that would give rise to an inference of discrimination. I've worked at Dade Pitney for 33 years. I have a stellar record. I never had a problem. That's probably enough to get me past this initial part. And the burden then shifts to Dade Pitney to do something that's really, pardon me, might not seem extraordinary at first, but is really unknown in the law. And that is Dade Pitney would then have to come forward and articulate, not prove, articulate a legitimate non-discriminatory reason for what happened to me. And in 95% of cases, what do you think that legitimate reason is going to be for why someone gets terminated, demoted, what have you? Performance, right? Performance. And what that does, which is extraordinary, it gives the claimants in these claims something to shoot at, right? Something to go after, which they didn't have before. And the way the case law has evolved since then is if the employee, the claimant, can show that that legitimate non-discriminatory reason doesn't hold water, then that in and of itself is enough for a finder of fact to infer that the real reason is that it was discrimination. And this is this concept of pretext that we hear about, right? So what does that suggest? It suggests that many of these termination cases that we deal with in court and that we handle in court are really about how good we can prove that someone's performance wasn't what it should be. And I can tell you there's all manner of documentation that we have that we encourage people, I'm sure you do all the time, encouraging people to come forward with documentation so that we can show these things. And nonetheless, I find myself like Garrison Keillor in the Prairie Home Companion, right? Where all the children are above average, right? I look at the employment records of people I am told are really, really bad performers, and I have a phosphorescent glow on my hands as I'm done. And I see people who bear no resemblance to what's been described for me in an initial client intake meeting. And why is that? Why is it that people don't want to do this? And I think over the years, what I found is fundamentally it is extremely difficult to look across the table at someone you work with, probably somebody who's your friend, somebody who's a decent person, somebody who has a family that you know about, somebody who has obligations, and tell them that they're really not very good at their job. It's not a lot of fun. It is also one of the single most important things that can be done in the workplace. So many evils flow from not having this kind of documentation there. I can tell you that all of the jawboning in the world doesn't mean a heck of a lot when you get to a jury trial, when you get to a CHRO fact-finding or a CHRO public hearing. The writing is king. It's crucial. It gives you a point in time where you can show, what do you hear all the time at performance time when there is something negative mentioned? I never heard anything about that. No one told me that. I went all year and right? it reinforces that fundamental point. And what I think each of you, and I do these sessions training managers how to manage other people, trying to get these points across. What I think is really important for you as the HR organization is the importance, the critical importance of your policing these performance documents and making sure that your business partners are appropriately documenting these issues so that we don't have claims that are unsubstantiated. And I can go through and just briefly run through what I find to be some of the key performance documentation problems. Too little, right? We've all dealt with that one. But there's also a phenomenon of too much. So if you are documenting every problem for a problematic employee, but you actually do nothing about it, and then we have notice of a disability, we have a workers' comp claim, we have a pregnancy, we have something like that, and then we act after that, the documentation that we were looking for actually becomes kind of an impediment, because the question then turns to, well, why the heck didn't you do something with these 50 things that preceded this? You only did it after this event that's protected. Not honest. Just simply not being honest. And its close cousin, which is the second from the bottom, looking for something nice to say. And you can pick these things out a mile away, right? There are 4 paragraphs about Joe put together the United Way luncheon, and it was a huge success, and blah, blah, blah. And then the last 2 sentences say something like, Joe failed to meet 3 of his 5 key objectives for the year, which was not great. He'll need to improve, right? And all of a sudden, when we get to a trial, understand what happens, right? That United Way luncheon becomes like the seminal event of the year and the most important thing that ever happened. Mentioning protected classifications in performance documentation. This is like toxic waste. Nothing grows for 1 million years near a mention of a protected classification in a performance document, even if it's done in a positive way. June came to work every day during the heat of her pregnancy and was an example to all of us in terms of how she put forward effort and all that sort of stuff. Just mentioning a protected classification in connection with a evaluative document is so damaging, so difficult to recover from if we need to. Really becomes problematic. Stereotypes. And I think back to the excellent point we just heard. Are you really making a decision based on something that's true, or are you making a decision based on a stereotype that comes to your mind quickly and easily? So if you look at Glenn and you're going to write a comment that Glenn at 61 years old is not very proficient at technology, you might have in your mind, this is the guy with the VCR at home that's 12, 12, 12, right? He can't even work that out. Right? So what do we need to do if we're doing something that feeds into stereotypes in documentations? My most important point, concrete examples. Concrete examples, to my mind, are the tonic that fixes performance documentation. And the Greeks are instructive here. 1 is an occurrence, 2 is a coincidence, 3 is a pattern. If you can get 3 solid documented instances of someone or good examples of somebody in performance documentation, you have yourself a very effective performance document. So what I suggest is this. I call it managing by Microsoft Outlook. It's not a great original concept, but send people emails. Tell them when they've done things that are good or bad. Either use a document management system or a folder or something, save them. And then sort them by date when you have to do performance reviews. Read those before you do the documents. And simply make reference to them when you do performance documentation. It takes away that whole discussion about, you never told me, I never knew. Well, yeah, here it is, right? It takes away, especially on mushy issues like interpersonal relationships or team play or that kind of thing. It really takes away a lot of that because you're talking about things that are very specific. And it moves the whole performance discussion into a whole nother realm. So if I had one message for you as somebody who tries a lot of cases and handles a lot of contentious issues relating to terminations of employment, you need to really work with your business partners to make sure they understand the critical importance of doing performance documentation and the absolutely debilitating results of not doing them appropriately. So termination meeting, I'll finish this up and then I'll turn it over to Lindsey. To me, we can talk about a lot of this. I think you should have more than one person in the room. Do you need to have the supervisor? Not if you're going to find him or her in the corner in a fetal position before this happens, right? That might not be helpful. But you need more than one person to be able to be there so that if there are crazy statements attributed to somebody in that meeting, you have at least two voices to refute it. But the most important thing to me, and the biggest problem I see, is this. It's not going to be great. It's not going to be smooth. Just get that out of your head. It's going to stink, right? How many people here have notified someone of a termination? How many do you say, wow, that went really well? It's not going to go well. It's not going to be fun. They're not going to be happy. You're not going to convince them. It is a notification. It is not a justification, and it's not a negotiation. And it doesn't have to be long. Joe, we're here to let you know that your employment's terminating. It's going to end effective as of it. Why? What's going on? You know, Joe, we've made a decision, and we need to move forward quickly from here. And you need to have your focus looking forward. It seems kind of cold-hearted. It seems kind of difficult. You want to express sympathy. People say things like, this is really hard for me, Joe. You really ought to know which. Joe is going to be infuriated when he hears that. It's just not going to help anything. He's like, well, I'm the one without a job. Quick, to the point. It is a notification, not a justification, not an explanation. And that is really the best advice I can give you. And of course, I prattled on longer than I'm supposed to. So we'll let Lindsey walk through things. Yes?
So we had a question about recording those meetings, the termination meetings.
Yes.
So, right, let's say the employee already knows, like he suspects what's going to happen at this meeting, or even let's say it's a performance review meeting and the employee's like, this isn't going to go well, this is BS. And so he says, I'm going to record this. And the employer says, no, you're not allowed to record it. And it looks like you're hiding something. So how do you handle that? Okay,
I think first principles, can somebody just record a conversation with you without your consent? No. Yes. Okay. Connecticut is what's known as a one-party state. If one party to a conversation consents to it being recorded, including the person who's doing the recording, which was presumably they do because they're doing the recording, it is legal. It is not. What is illegal is what's called eavesdropping in Connecticut statutes. And that is if I were to leave a phone here with or a tape recorder or whatever it is and recorded it and said, all right, I'm going to ask you guys what you thought of Lindsey in my presentation, but I'm going to leave the room and you can just discuss it. And then I come back, no party to the conversation's consented to it. Also, telephone calls, different, uses a federal instrumentality. All parties to a telephone call must consent to it being recorded, right? That's why when you call your bank or whatever, they say, for quality assurance. No, it's not for quality assurance, right? It is for saving it and making sure that you consent to it being recorded. So that's the first level of this. Whether it's in the investigation context, the coaching context, the termination meeting, you are not required to allow an employee to record. You have the right as the employer to say, no recording here. If the employee insists at a termination meeting on recording, I think the answer is very simple. We're done here. Here is your termination paperwork if you have it, which under our new Personnel File Act, we have to give immediately to employees. Here's your termination paperwork, and we'll be on our way. You're not required to do it, but understand this. Notwithstanding the fact that you might not consent to the recording happening, it comes into evidence pretty easily. All you need is the employee to say, I was there, this was an accurate recording of what occurred in this meeting, in this conversation that we had, and that pretty much comes into evidence. So Recording is a real thing. It happens much more frequently. I would say it's present in litigation in maybe 15% of cases that come up where someone has recorded something. So just remember, if you ask someone, what's the single most valuable asset you have? A lot of people say, well, my 401k, my house. It's really your job, right? Your ability to earn this living over a long period of time, the ability to support your family, to accumulate wealth in your 401k, all that stuff. People will fight very hard to keep the most valuable asset that they have. And that's why what all of you do with your business partners is so important. So with that, I'll turn it to Lindsey.
Joke. So I am going to turn now to talk about conducting effective internal investigations. So the first step is, how are you going to get these complaints and what are you going to do about it? So they can come to you in a variety of situations. The first and most common will most likely be someone coming up to you directly as an HR manager and saying, you know, someone harassed me or someone made a comment that didn't make me feel that great. So that's one situation. Another way is you yourself actually witnessing the conduct that could be concerning. Another common way is if a third party or a customer comes to you and complains. When these things happen, we say, when in doubt, investigate what happened. And here's why. So conducting an investigation can have many added benefits other than just getting to the bottom of what happened. The first being, it can foster the resolution of disputes. What could happen is someone complains about something that they really just wanted an apology for. So actually looking into what happened can foster that conversation that otherwise wouldn't have happened. It can also enforce your company policies. If you're actually digging into what happened, that sends a message to everyone that, you know, the company takes these policies seriously and we're here to enforce them. It also can form the basis for disciplinary action, which we'll get to toward the end of our presentation, anything up to and including termination like Glenn just talked about. But most importantly for us as outside counsel, they can be used in the future for legal claims and to limit your employer's liability. There is a Supreme Court decision that actually held that and confirmed that crucial and fair investigations are important to limiting your liability, especially when they're coupled with effective remedial action after the fact. So, however, if they are conducted ineffectively, though, they may impede your ability to make the right decision. They could actually result in liability. So we're going to cover some of the characteristics of what an effective investigation looks like, so that way you can be doing it the right way. All of these characteristics on this slide are important, but I'm just going to highlight two of them. The first being objectivity. So not just being yourself objective, but also having that perceived objectivity by the witnesses, by the people that you're interviewing is really important. You could already have a preconceived notion about the parties that you're investigating. It's important for them to feel that you are being fair and impartial in this process. The second important thing is promptness. You need to investigate quickly. As soon as a complaint is made, it's important to begin that investigation and take appropriate action as soon as possible. The problem with waiting is that memories fade over time. So if you're waiting a week or 2 weeks, I don't remember what I did yesterday morning for my routine. So it's important to get that out there early so that way you can get the most effective and accurate information. Second, documents, especially your emails, electronic documents, they may not be there anymore. They may not be available. So conducting an investigation promptly is super important.
Lindsey, let me ask you on confidentiality. Let's say I'm accused of sexual harassment and I say to you, look, I want you to confirm for me this is confidential. You're not going to talk to other people about this. This is not going to happen. What's the right answer to that? Do we want to promise people complete confidentiality, partial, no confidentiality?
Right, so you don't want to promise anything in an investigation, the results, confidentiality in particular. The reason for that is anything that's said in the investigation, in the interview, you are representing the employer. So the employer, by your knowing that knowledge, then knows it as well. So you can't promise anything to be confidential because it will go back to the employer. Also, anything, if you if litigation results as a result of a claim after this investigation, you don't want to be limited to what you can and cannot disclose, particularly in your report at the end of the investigation. You want to be able to rely on everything that you hear.
Yeah, and I think one of the other things that gets lost in this is the notion that we'll keep this confidential. It sounds like it's a very good thing to say, but the person accused has a right to have other people asked that might provide exonerating information, right? This isn't a star chamber. It's got to be a fair process. So I think, what I tend to say is, look, we're not going to disclose this beyond the circle of people who need to make decisions on it or who we need to consult. But understand that if there are other people who they say were witnesses to this or who can discount or prove or disprove this, we're going to talk to those people. We need to, because those people are part of an appropriate investigation, and that's not going to maintain complete confidentiality.
Yep. Okay, so one of the most important considerations before you start your investigation is who should be conducting the investigation. Is it you? Some questions that you should ask yourself are you a witness to what happened? If so, then you should not be the one conducting the investigation, because you'll be a witness and actually be interviewed by who is conducting the investigation. The second question you should ask yourself is your boss or someone that you work closely with the target of the investigation? If so, then there's a lot of problems with that, because then there's a conflict with your own job and concerns about whether or not you could be retaliated against, which we'll touch on, if you're then investigating into conduct of your boss. And then thirdly, should you retain a law firm to investigate? And I promise we're not here to just pitch ourselves to investigate. There are some considerations that you should look into, whether or not someone removed from the situation internal should look into this, or whether you should hire outside counsel for this. The first being the seriousness of the claim. So if you have a claim where, what would be an example of
if you have a claim involving an especially dangerous situation, a high-level kind of situation, you might want to be thinking a couple steps down the line. Who do I want as my witness, and what are the optics I want to make sure that this appears to be an appropriate, impartial investigation, right? And a law firm provides you with an excellent set of dynamics in that regard. You have somebody who's independent, presumably, who's not affiliated. You have somebody who has the imprimatur of expertise in this area. And you also have the ability to have the attorney-client privilege. And in some cases, you may want to decide what you want to do with the investigation. Do I want to keep this investigation somehow under the cloak of the attorney-client privilege to the extent possible, and I'll disclose it later as I choose, or am I going to be out front with this? Getting a law firm involved facilitates all of those interests, in addition to giving Lindsey and me work to do.
Okay, so you've decided who you want to conduct your investigation. For the purposes of our presentation, we're going to assume you chose yourself. So the next thing that you're going to want to do is understand the issues that you're investigating. You want to clearly define at the front what the scope of the investigation is. When you are conducting your investigation, it may lead to several other issues that you may want to investigate separately. But if you have defined what your scope is at the beginning of the investigation, it will lead to a better, more thorough investigation of what the actual issue is. We also encourage at the beginning, you want to do all of your fact-finding that you can do without asking anybody else for any information first. So the things you can do are looking at your own company policies, understanding, do we have a sexual harassment policy, and what does it say? You want to identify other sources of information. So were there witnesses to the incident? Are there other contemporaneous documents such as emails, text messages, photos? You also want to look up the history of the employees involved. What's important about that is, has this employee been complained about before and you just weren't involved in that? What we mean by statistical evidence here too is if an employee complains that they were denied a promotion due to their race, who else has been promoted? What were their demographics? You want to have those statistics before you start investigating. And then lastly, prepare your questions in advance of the interview. You don't need to be tied to a script before you interview. There'll definitely be questions that you have as you interview. and certainly want to ask follow-up questions, but it's good to have kind of a guide before you go in.
I often think that the preparing of the questions is really the helpful thing, much more than having the checklist. Because one of the most important things we learn, and I know Tiffany knows this, Lindsey knows this, going into questioning is listening very carefully to the responses you get and not just being checklisting things. Because there could be all manner of questions that occur to you as you get the information that's unfolding from kind of the initial inquiries you're making.
Exactly. And our last question is, does the situation involve a collective bargaining agreement? I know this may not apply to all of the employers in the room, but I did hear a question earlier about a collective bargaining agreement. And there's several considerations that you need to know before you start interviewing people. The first being that if you have a union representative employee that you are interviewing, if they request before the interview begins to have a union representative present, then they are entitled to have that union rep there if they reasonably believe that the interview will lead to discipline. So the first part of that is the employer has to request the representative in order to be entitled to one. The second part is that it's looked at, the right to have a rep is looked at from the employee's perspective. So do they reasonably believe when they're sitting in that room that they could be subject to discipline? So just telling them, you're not the subject of this interview doesn't mean that they're not subject to discipline. So you have to be clear in order to refuse them a union rep.
So Lindsey, what about outside the collective bargaining situation? Employee sits down, you tell them we're doing an investigation, and they say, I want my lawyer there. I refuse to answer any questions unless my lawyer is present. Do they have a right to demand that?
No, so there's no right in Connecticut to have your outside counsel or legal representative present in an employer-conducted interview. That being said, there may be a practical consideration there that you might want to have outside counsel there if it's requested, because that kind of bolsters the credibility of your investigation, but there's no right to have one. Who can be a union representative? So only a business agent or a employee or officer who's related to the employee's union can actually be the union representative. So if the employee asks for, again, a private attorney or a family member or someone else there that has no affiliation with the union, they're not entitled to be in the room.
Do we have a question, Diane?
Yeah, but can we get a mic? Pete? I have a mic.
So if a person asks for a union representative, is the HR person performing the facilitating the questions and interviewing, should I think about having another management person come into the meeting?
Yeah,
Or does that make it too awkward, or what would you recommend?
I think that's a kind of a fact and circumstance question. If you feel that there's a likelihood that what you say might get misrepresented based on past practice, or there might be some other kind of antagonism, difficulty, and especially difficult steward or union rep, I would absolutely have someone else be present in the room during that interview. But there's, again, I think that's one of the play it by ear, use your judgment on the fly kind of questions.
So we only have, about 5 minutes left. So I'm going to do a question here. Okay.
Hi, thanks, Phil. So we're non-union, and I had a circumstance where we had to do an interview, and we specifically asked each one that we interviewed whether they objected to it and that they would keep it confidential and sign a paper that said that. Is that okay to present to people?
You asked them if they objected to the interviews?
If they would agree to speak on their behalf.
Yeah, I don't know that I would go down that road, because I think it gives folks the notion that they're holding a few more cards in this thing than they actually are. And it might make the interview more difficult.
I mean, what if they just outright say, no, I'm not doing that?
Well, then I think it becomes a disciplinary issue at the end of the day, and the inferences that you can draw from the investigation are handled accordingly, right? So if someone who's accused of taking an inappropriate act, saying sexual harassment or whatever else, refuses to be interviewed, I think the standard course is that you can draw an inference against that person on the allegations that are made based on their unwillingness to participate in it.
Anybody else?
Any other questions before we forge on? We've got about, I think, what, 5 minutes, Diane? Little left?
Yeah, yep. Okay.
Okey-doke. Well, let's get the interview started. So how do you start an interview? First, if you don't know the employees, you want to make an introduction and set that comfort with the employee that you're interviewing. And you also want to communicate the ground rules. So you always want to emphasize you need cooperation and the truth. Your role here is as a fact finder. So you want to let them know that you just want to find out what happened. You also need to tell them that they need to report any retaliation from their participation in the investigation. And that's really important. You also need to disclose information that's later remembered. So if for some reason they don't remember in the interview, it's kind of a stressful situation, encourage them to follow back up. Additionally, there's consequences of noncompliance that Glenn just touched on. There's discipline that will result if they do not comply with the request for information. Additionally, just stating what you're investigating, just the general topics, so that way they can start thinking about what actually happened.
I also think, just as a general matter, you need to think about what you're investigating and what the investigation looks like as a result of that. If you're investigating a very serious allegation of systemic sexual harassment in your organization or something of that sort, it's a very different situation than if somebody says, you know, Joe uses the F-bomb and some inappropriate language or whatnot, something that's, you know, by degree much lesser, right? So an investigation doesn't, you know, have to be, you know, kicking open the door, I'm here to investigate, everybody against that wall, we're gonna, you know, it doesn't have to be that formal. In a lot of cases, it can just be talking to one person, talking to another person for a low-level situation. What we're talking about here really, I think, is something that has more high stakes.
Okay, so now you start asking some of the questions. We find that it's helpful to go in a chronological order. That way, you're starting with the earliest instance, and you can ask, did anything happen before that? Then if not, go, okay, what next? Then what next? And then you won't miss anything. You also want to start with broad questions. We kind of call this the funnel method. You start broad and then start asking follow-up questions, the who, the what, the how, the where, and it's really important to get dates. You also want to focus on facts and not conclusions. So if, for example, someone says, you know, Mike's really flirtatious, you want to ask how? What was the underlying conduct that led you to believe that he was being flirtatious? So getting the facts, getting concrete examples is also really important. And then you want to ask for them to identify documents and other witnesses that can lead to further interviews. And again, you're there as a fact finder, not to interrogate. Things to avoid. Definitely don't interview in groups. And the reason for that is you don't want witnesses to then rely on what other people's recollection was of the incident and then just tag team on, you know, what they said. It seems like common sense, but don't lock your witnesses in rooms. The reason these things are on these slides is because, you know, we've seen this happen before, so definitely don't do that. Also encourage you not to tell your witness what other witnesses have said for the same reason to not interview in groups. Also don't tell the witnesses what you think. You want to keep them guessing because you are there to listen to actually find out what happened, and telling them what you think takes away from that objectivity that we talked about earlier. You also don't want to express sympathy, which can be hard when you're interviewing who is alleged as the victim. This goes back to being objective again. You don't want to let them know what you're thinking before you've actually concluded the investigation.
Right. Imagine if you're accused of something you didn't do, and you hear the interviewer who's talking to the person, you know, spoke to the person making the complaint and expressed sympathy. I'm so sorry this happened to you. It sure sounds like prejudging an event, right? What you owe people is concern and an appropriate investigation to look into it. Sympathy comes after you've made determinations as to what happened.
Okay, so Glenn touched earlier on how important documentation is. Your notes in your interview are also really important. You want to write down exactly what the witness said. You won't be scribbling because you want to be listening as well. So that's why we encourage you to also potentially have someone else in the room that can be the note taker for you. But you want to write down the facts. So you don't want to write down things like, Susan seemed really nervous. You want to write down that, okay, maybe she was fidgeting or things like that. You don't want to draw conclusions in your notes. At the top, you'll want to include the important things like the date, the time, the place of the interview, and as always, collect information. Don't just disseminate it out. And lastly is the investigation report. We'll touch on this really quickly because we only have a few seconds left. You'll want to lay out all of the claims raised, and then the most important thing is to draw a conclusion. Are you substantiating the claim? Meaning, did you find enough evidence to find a reasonable cause to substantiate it? Or is it unsubstantiated or inconclusive? And with each claim, you just want to write down all of the facts.
And remember, you might need to be making credibility determinations as part of this process. That's a legitimate part of the process. This person seemed credible to me for the following reasons. This person did not. Well, we see a big red 0 up here. Lindsey and I really appreciate your time and attention. Thanks so much, and I hope you all have a terrific day.
John,